complete my opening statements, I will respond to your question.
Mr. Nichols, can I ask you a question?
Yes, sir.
Are you an attorney? Or
No, sir, I'm not.
Or are you just an interested citizen?
I'm a citizen.
Okay, that's all I wanted to know, and I thank you very much.
Thank you. And the first witness I'd like to call is Mr. Dave Stevenson with the Caesar Rodney Institute in connection with the permit, the application, excuse me. There are economic benefits that are alluded to. Mr. Stevenson will provide evidence pertaining to those so-called economic benefits that
I'd like to make an objection for the record. We've objected, and we've told Mr. Nichols to object to bringing new witnesses and new evidence in this proceeding that wasn't put before the Secretary. In my view, what this board ought to be doing is looking at the Secretary's decision, looking at the things the Secretary looked at, so we object to witnesses that weren't available and didn't make their opinions known to the Secretary as part of this proceeding. A second point that I will have on Mr. Stevenson, but I'll let him initiate his testimony, is I don't think he's an expert in a particular field. I'm aware of him and know that he's a very smart and thoughtful individual, but I don't think he's got any expertise that requires the submission of expert testimony.
It does seem a bit odd that Mr. Nichols would be able to come here today and argue that the Secretary's decision was wrong based on information that the Secretary never had. I just want to join in Mr. Schoell's objection again, considering additional witnesses and documents, some of which, will be objected to as hearsay in any case. I don't think it's proper to go forward today by allowing him to create a new case for the board to hear. Thank you.
it's inconceivable to assume that every member of this public hearing who are allowed to attend could have been in attendance at that meeting, nor is there anything in the regulations or statute that indicates there's a requirement to attend. There's no requirement whatsoever. In fact, I could argue that I didn't even have to be there in order to be an appellant. So I think that the scope of the hearing issue needs to be resolved so that this testimony will be allowed and it won't be challenged. There are issues that have since occurred, since have arisen since the public hearing pertaining to the fuel cells that couldn't possibly have been discussed at that time. So it would seem that on appeal, although I'm the only appellant because I paid the fee in the timely manner and the time allotted, anyone should have an opportunity to be heard. That's the opportunity for us to get a second look at what the Department of Natural Resources has done. Position as a citizen to do a proper analysis. It's the department's position to do a proper analysis. So counsel for the department is objecting to me providing expert testimony that illustrates that the department made errors in their application. Well, then I'm willing to grant that they did make errors in their application, because that seems to be what the objection is. All we're going to do is address those issues that perhaps in some cases are only peripherally responsive to my testimony, but are definitely factual with respect to the errors in the application. All this is part of the public record. The testimony speaks to everything that has already been submitted by the department. There really isn't any new information except a proper interpretation of the information that was already provided. It's not my fault the department made mistakes. It's the department's fault that they made mistakes. And
Once again, I'm going to poll the board for their views on the guidance we've just received. Mr. Wheatley?
In my experience and the way that I'm used to hearing cases type, typically they are in fact on the record. However, I understand that the law perhaps indicates that it's a de novo proceeding. But at the end of the day, I think the question will come down to not so much that new evidence is presented, but whether or not Mr. Nichols can present evidence that affects the interpretation of the existing evidence, and is that problem, the fact that they got it wrong, is it egregious enough to change the decision? So, that's kind of where we are. But I will tell you, I'm not interested in hearing a lot of new stuff. If you're going to comment on what's in this record and have people who are going to comment on this record, I am all ears. Happy to hear
Mr. Holmes?
To review what Mr. Wheatley said, I don't want to hear the same person or 6 people get up there and talk about the same thing for 25, 30 minutes and take up 3 or 4 hours. We're all busy people, we all got a lot to see, but I think you should have your day in court to be heard. So that's how I feel.
Mr. Burton?
I feel the same way. I mean, I think it should be pertaining just to the order.
Mr. Supermanian?
I give that we give the secretary for the validity. I agree.
Mr. Buick agrees? Okay, we seem to have consensus on